prosecution has rested. We're going to go to lunch. What do you think is going to happen when we get back?
You know, it's hard to say, but I get the feeling that right after the state rested, she called the parties up to the bench. They whispered a little. They probably talked about logistics, okay, like, so what's going to happen next? And the defense, I mean, they could have just said, well, we're just going to rest, and they could have just rested right then, meaning not put on a case. Or maybe the defense said, well, before we can go forward, we got to cover some things outside the presence, because then the judge said, well, we're going to take an extended lunch, which was only an hour and 15 minutes, which really isn't that extended, frankly. But maybe she's building in a little bit of time so that they can do some outside the presence stuff before they bring the jury back in.
Yeah, it's so, you know, it's, you know this, it's...
I'm watching Kobe.
Uh-oh, something's happening. Okay.
It's live stream. It's live.
Okay.
You can start on this one.
Okay. Judge, can I put one back in?
Yes. We are back on the record in cause number F1875401 outside the presence of the jury. There is a motion that the defense wanted to put on the record.
That's correct.
Mr. Moore, you may proceed.
Thank you, Your Honor. Your Honor, at this time, after the state of Texas has rested its case in chief against my client, Mr. Billy Chemirmir, we're going to ask the court, we're moving the court to enter a directed verdict on behalf of Mr. Chemirmir based on the fact that the state of Texas has failed to make a prima facie case, proving its case on each and every element that they allege against Mr. Chemirmir in this call and in this indictment, and we respectfully this time ask you do so.
And that motion will be denied. And we are off the record. Off the record. So.
Okay, throw us back up. Okay, so Aaron, they've gone off the record, and the state, Kobe Warren has just called for a mistrial, which is pretty much par for the course standard operating procedure, right?
Not really a mistrial. What he asked for is he asked for the judge to enter a directed verdict, which would only be appropriate in a case where after the state presents its evidence and then rests its case, if the court were determined that the state had failed to prove any material element of the offense, then the court could enter a directed verdict in favor of the defendant. So it's kind of a standard and necessary move for the defense to make after the state rests. You know, it might seem or feel a little ridiculous to hear the defense ask for a directed verdict of not guilty or innocence, or to dismiss the state charges after the state's just put on what appears to maybe be a pretty compelling case to prove its indictment, right? But that is, yeah, that's just a matter of course for the defense to do after the state has rested.
Yeah, and I misspoke. I called it a mistrial. But you're right. But this is in all the trials I've watched. This pretty much always happens. Is there would there ever be a time you would not?
Well, the defense counsel has been talking about a potential jury charge, and right now we are talking with State's Attorney Jacqueline O'Connor in regards to some suggestions that have been made by the defense counsel. You may proceed, Ms. O'Connor.
Thank you, Your Honor. It's the state's understanding that the defense is requesting lesser offenses of murder, burglary of a habitation, and theft. And the state would request that the defense make a proffer of what the evidence is that they believe would entitle them to those lessers.
Mr. Warren?
Judge, I believe that, for the defense, we believe that there's been evidence presented that if the jury did not believe that, as we all know, the capital murder is murder plus. And so if the jury did not believe one of those allegations that are contained, and I believe in the indictment, it is
no burglary, no robbery?
correct. If theoretically they could believe that it was just simply murder. They don't believe it was murder, then it would be an acquittal if it wasn't a murder in either of those burglaries or robbery. Also, in addition, there's been evidence submitted before this court, before this court as well as this jury, that if they didn't believe any of those things, however, they did believe that he was in possession of stolen property, then a theft would. could also be applicable here. That we believe there's been a scintilla of evidence that more than sufficient for our lessors to be included in the court's charge, and we're going to request such judge.
So the lessors you're requesting is murder
Yes, Your Honor.
and theft?
Yes, Your Honor. Burglary?
So you're burglary?
Yes, Your Honor.
So you're asking for murder, burglary, and theft,
And robbery.
and robbery?
Okay, okay.
What about, it'll at least be aggravated robbery, I mean, aggravated robbery.
Well, so here's the deal. There is absolutely no evidence that the defendant was there and murdered the victim, but didn't rob her. It's the exact opposite. In his statement that was played for the jury, he said, "I was not in that house. I did not kill anybody." So we have no evidence showing that it was just a murder and not a robbery. Same with the Burke hat. I was not at that house. There is no evidence that he was just there and he robbed her, but he went into her house and stole from her, but didn't kill her. So the state believes, I think we'll agree with the theft, because I think in his statement he did say that he did agree or did believe that potentially the jewelry box that he bought from this unknown man could have been stolen. So we're not objecting to theft, but I just really don't think there's any evidence before the jury that would say if he's guilty only of murder or he's guilty only of Burke hat.
And Judge, in reply to that, in regards to even going on with Mr. Turner stated, Mr. Chemirmir's statement, that if he bought that property knowing that it was stolen, that it could be stolen and it would have been burglarized from Ms. Harris's home. And so we would ask that there could be a party, it could be a party to the judge, so it's up to the jury to make that decision.
But there's no evidence that he solicited, aided, encouraged, did anything in furtherance of a burglary that would make him a criminal at all.
And then he would then be a party to the capital murder, bringing us all back to where we are with just being an encounter.
So just so the court is clear. The state of Texas is saying that basically in our dummied down summarized version, you almost got to admit it to get it, right? You have to either admit you were there, around, participated, blah, blah, blah.
Right, even in their cross-examination, they're not admitting that's his car, they're not admitting that he's in possession of the cell phone, they're just saying that's his phone number, that's his device, but we don't know who has it. Yes, he has a car like that, but we don't know that he's driving it. So they are denying all of the things that we're trying to prove up to show his presence with the victim at the scenes, those things. So if they're saying he's not there with the cell phone or he's not in the car, then how are they going to say he's at the house? He's already told everyone that he was not at the house.
And in fairness, the defense is requesting that although he may be in possession of items that he does not know where they came from, that could possibly make him a party.
So at minimum, the burglary.
A party to the burglary, but not the.
Right, no, we don't have to prove how that occurred.
You're correct.
But if they're alleging that that property was taken from Ms. Harris, so from her home without permission. In and of itself, that's a burglary. Someone did that.
Okay.
And so he has that property. And so if there's evidence or there's an argument that can be made that in him receiving that property that was burglarized from Ms. Harris, that he's a party to.
But you have to
It
have
didn't
knowingly or
have-
intentionally done that.
And it also didn't have to be a burglary for him to have the stolen property. I mean, what's the connection to that?
We're alleging it was taken at some point from her home without her consent.
We're alleging it was taken from her, yes. I mean, in terms
From
of,
her
it was
home.
stolen from her, so that's a theft.
Yes. Which the defense and the state have agreed that would be theft under the scenario that you're giving, Mr. Warren. Those elements, I guess I would call them, would be theft. It could be theft of, stolen property. It could be a theft by any number of ways. So everybody agrees that it's a possibility that it's theft, or as we like to commonly say, maybe some hot goods were purchased. So everybody is in agreement with that, with the theft.
Yes,
So the contention is the defense wanting a lesser of burglary and murder. I think we kind of canceled out the lesser of murder. Correct? We go by the law.
If that's the court's ruling, then yes. But we would still reflect the ruling on it.
Okay. So, and I will do further research. So the defense wants a lesser of theft, a lesser of murder, and you wanted the lesser of burglary
And aggravated robbery.
and aggravated robbery.
And it's up to the judge, and we can request it and you can deny it. It's that simple. We don't have to.
And I mean, our arguments would be the same as to aggravated robbery or robbery. Again, like if there's no, if his position is I wasn't there, I didn't go in the house, I didn't harm her, I didn't, what would be the deadly weapon in an aggravated robbery? Again, it would be capital. It wouldn't.
Let's ride that horse. Let's ride that horse.
So our position would be the same as to ag rob, and burglary. In terms of the evidence that's been presented, we don't think it rises to the level of entitlement to balance those lessers.
So is there any particular statute of, any particular subsection of the theft statute that you're considering?
I think
Oh yeah, we did talk about that, Judge. So we did talk about 3103B, and I think we agreed,
initially I said 31
You say three additional.
C3.
which applies to like pawn shops and things of that
Yeah.
nature, but I think that we've just agreed we're gonna go under 3103B.
Yes, ma'am.
And then the amount is the 750 to 2,500, which would be a Class A misdemeanor. I mean, technically, we haven't offered evidence of
The value.
the value, but that's what the parties have agreed that
Yeah.
Okay.
we're comfortable in submitting to the jury.
Of
Right.
21.
And Judge, we object to any reference of any misdemeanor language. It can track the misdemeanor language, but if the court decides to include the misdemeanor language, that it will not be referenced, this is a misdemeanor. It's not relevant that the jury know that.
Well, once we get to that decision, it is a punishment range that they will have to know about.
No, Judge, you're the decider. We're going to you for punishment.
With the lessers, gotcha. All right, so.
Wait, so I just,
Burglary.
It would say
Go ahead.
it would say in the charge, in the verdict form of the Class A misdemeanor of theft or the state jail, right?
No.
I'll have to pull up one, I'll have to find out, but if I'm not,
I think we're agreeable to that. We
Yeah,
want to
yeah.
include the.
I think what you're thinking of, Glenn, what is the original charge, I have to put the punishment range, but the lessers, it does not lay it out, Class A, Class B, it'll just, if you find that person.
The difference though, Judge, is that normally the jury would be foredired on the different ranges of
Exactly.
punishment for all their thefts, and because we didn't do that, they have no idea that there is a wide range from a misdemeanor all the way up to a felony, depending on the value of the.
And I would go one step further and say that we're going to first address the guilt innocence jury charge.
Correct, and more
If
importantly,
we were to get the punishment, this would go into a punishment jury charge.
If there is a punishment
if
jury.
Mr. Chemirmir
If
is not
he is
elected,
found guilty of the lesser, Mr. Watson, it would be a punishment.
but he's
We are
elected,
going to you.
yeah, we're elected to come to
Okay,
court.
all right, you're right.
So it's not relevant. No.
Anything further in regard to the guilt innocence?
Not for the defense judge.
I've been reviewing Mr. Watson's edits, and so I'm almost done with that. There are a few that I can agree to, so I was just gonna make those corrections, and then whatever lessers the court rules on, we'll add those in, and then we can have a final version for everybody to review. There are a few of his edits that I'm not agree, or that were not agreeable to. Did you want to do those now, or you want to do those after lunch?
We can do them now.
Let's do them now.
Okay. Do you have copies? Wait, you didn't offer this, you want to offer it?
Yeah, that's fine. For purpose of the record, we'll offer defense exhibit number 2, which is just our version of.
It is our request to jury instructions.
Okay.
And it's basically, Judge, they took the Word document that we sent them, and then Mark used the editing tool within Word and added or deleted certain things that they were requesting.
Because this is an incomplete one, but it is a version of it. This one does not contain that one.
Okay.
But we will offer defense exhibit 2 for the record. Yes,
And does the state have any objections?
Not from there.
Okay, so defense exhibit number 2 will be admitted for record purposes Thank you.
And Judge, if we can just go by this page by page, if that's okay.
That's fine.
Okay, so on page 1, the proposal is, it did say, and you were instructed that you may read these instructions as a whole. They're proposing to change it to say that you are to read and follow these instructions as a whole. We would object to that language because the case law says that they may read it as a whole, but it's not a mandatory instruction that's to be given, and so we don't feel like that's consistent with the case law. Mark, did you want to?
Judge, we just stand on our submission.
Okay. I'm just taking notes and then we'll.
Okay. And then moving forward.
I'll tell you what, Judge, I do want to comment on that. I submit to the court that for the whole purposes of our argument regarding jury charge, that the pattern jury charge of Texas is suggestive. It's not mandatory on the courts. It's not binding. The courts can use any approved or anything that is that the court decides that it has been used in the past, and it is not error to use another version. And that's some of the language that we've used. And then also some of the language we have put in here is in the pattern jury charge.
Okay, and those are, yes, got it. And I would agree with that. However, what I was citing to is the actual case law from the Texas Court of Criminal Appeals, which she is bound to follow, does not use the word must. It uses the word may. And so it's a permissive, it's not a mandatory instruction that has to be given. Okay, and then on page 6, there was a request to add the language, any further find beyond a reasonable doubt. We're not objecting to that, and I've already added that language in. And then additionally, they're asking for us not to use the term the deceased. They wanted to use the victim's name, Lou T. Harris, so I did make those changes as well. We're agreeable to that. And then we're obviously objecting to these lessers, as we've stated, so that'll be for the court's ruling. I do have proposed versions of the lessers if the court is inclined to give them any of the lessers, and so I guess we can iron that out when the court's ruling. I would agree. I would definitely object. On page 8, he has these separate paragraphs in bold, where it's, if you have a reasonable doubt as to whether he committed specific offense, and they're singled out. And I don't feel like it's proper for the court to single those out. We usually do that in one paragraph where you say, you know, if you have a reasonable doubt, if he's guilty of a greater offense or any of the lessers, you resolve that in his favor. So this is basically instructing them. Yeah, and it's calling attention to them, and it's directing them to find him not guilty of capital murder, which goes against this concept that they're to read it as a whole and decide at the end. So we would object to that.
Your Honor, may I respond?
Yes.
That bold print that's not, that was put in there. I did it by my computer. It wasn't intentional, or it's not intentional. And we're more than happy to put that in regular type without the bold print.
Thank you. And anything further on 8?
No, Your Honor. And I think that would be the end of it. There's no, as far as I can tell, there's no other suggestions on pages 9 through 14. And then, of course, obviously, the verdict forms will be amended to add whatever lessers the court decides.
There was one on 9, that you were okay with that? If you not go on, or if you have a reasonable doubt?
Oh, yes, that language, so that wasn't included in the original version because there were no lessers, and so when the lessers go in, there's that instruction that's like, if you do not so find, you will next consider this one, and then you will next consider this one, and then at the end you say, you basically instruct them that if, you know, if they can't agree as to which, they must resolve that in his favor.
Yes.
Or acquit.
10, 11, 12, and 13.
Your Honor, we are asking for the language, if you have a reasonable doubt whether or not the defendant committed the offense of capital murder against Luther Harris, you will next consider whether or not the defendant committed the offense and whatever lesser included you put in there.
Yes, that's pretty much standard. So that will be. here's what I have. I have, based on the documents that I have received, which is defendant exhibit number 2, that there is an objection by the state on page 1 in regards to adding the language of may read these instructions. Is that correct, Ms. O'Connor?
The original version said you may read these instructions as a whole, and they're asking to say that you
Oh, that's right.
are
to be read.
Right, and so we would be objecting to that mandatory language. We would just ask that it be instructed to say may.
Gotcha. And the next objection by the state would be on page, well, actually on page 6, everything is agreed to, correct?
Yes, Your Honor.
Okay. On page 7, the state has objected to the language or the, what is it? In which,
We're not objecting to the transition language where it would say, if you do not find beyond reasonable doubt, or if you cannot agree, you will next consider whether the defendant is guilty of, and then whatever the lesser would be. We don't object to that transition language, but we are objecting to the requested lessers,
Okay.
other than that.
That's what I needed to hear. Okay.
And Mark, that paragraph that you're requesting on the bottom of page 7, did you pull that from the counter jury charge?
Yes, it's in 3, well, I got it out of the, yes, I don't know. I can find it in a minute.
And would you want that at the bottom of all the lessers, or like after capital murder but before the lessers?
I would like it in the bottom of all the less.
Kind of like where it would instruct them what to do when, like kind of at the bottom where it's telling them, you know, you have to resolve it in the defendant's favor. and-
Yes.
Okay.
Yes.
Yeah, we won't object to that, Judge. The bottom of page 7, it is not necessary for you to acquit the defendant of the greater charge in order to consider a lesser offense contained in the charge. Because that's consistent with telling them they can read it as a whole.
Yep.
And then, do you agree or you disagree with the language? If you are unable to reach an unanimous verdict regarding the charge of capital murder, you are instructed to resolve that issue in favor of the defendant, and next consider the offense of XYZ.
Yeah, that's them objecting to the lesser, right?
Are you talking,
What did you say?
are you talking about the page, the top of page 7?
Yes.
Just that transition language?
Uh-huh.
Basically, like if they're not able to agree, if they don't believe beyond reasonable doubt, or if they're not able to agree. I like to include that language. It should say, if you do not believe beyond a reasonable doubt, or if you are unable to agree, you are instructed. Well, I don't know that you can tell them at that point to resolve it, because they're supposed to read the charge as a whole. So I think you should just say you will next consider the lesser offense of, and then whatever that lesser would be.
Okay.
So everybody's, so we are in agreement of the transitional language on the page, top of page 7, or?
Well, I don't think that it should say you're instructed. Judge, how about this? Over the lunch break,
Yes.
I will make the changes that we agreed to, and I will give the proposed charge to Mark, and he and I can iron all this out, and then that way you're not having to, would that be agreeable to the court? And like, so the things that we agreed to, I'll add them in,
Okay.
and then that way we're only talking about the language that we're objecting to, that as opposed to like going line by line.
Yep, I think that will work. So the only other one that was left was page 8, and that is the objection to the lesser. So I did that. Okay.
And then just one more thing in regards to just the charge itself. The defense would move the court to instruct the state to elect to which paragraph that they are proceeding under. There are two very distinct methods in which they charge Mr. Chemirmir, one being capital murder with burglary, the other being capital murder with robbery. And we believe that a jeopardy issue would attach in regards to the way that they alleged it, and it would be a violation of his 5th, 6th, and 8th Amendment rights. And so we'd ask that and move this court to instruct the state to elect which paragraph they would proceed on.
Your response, Ms. O'Connor?
Judge, we're allowed to allege multiple manner and means of capital murder, and the jury doesn't have to be unanimous on which one of those. 6 can believe it's burglary, 6 can believe it's robbery, and so there is no requirement under the law, and it's also not a violation of any constitutional rights for us to include all those manners and means in the jury charge.
All right, thank you. At this time, the defense's objection and request will be denied and overruled in regard to making the state elect which manner and means that they want to choose, or which paragraph. Anything further from the defense?
I don't think so, Judge, at this time.
All right. Anything further from the state?
No, Your Honor.
All right. Well, we are officially at our lunch break, which is 12:40. Well, let me see the lawyers up here real quick.